Welcome to Money Matters TV. I'm Patty Tawadros. I'm going to be your host, and I'm joined by my co-host, Rob Bovarnick. It's nice to see you from Bovarnick Associates, right?
Yep, good to see you again, Patty.
And then your friend is joining us a little later.
That is correct.
Bob Zielinski, right?
Yes, Bob.
From the law offices of Bob Zielinski.
The law offices of Robert Zielinski,
Robert
LLC.
Zielinski, LLC. So how have you been?
I have been terrific. And yourself?
Yeah, very good.
Yeah. Anything exciting going on in your world?
Yeah, lots of exciting things. Growing my business. I'm in the Goldman Sachs 10,000 Small Business Program.
Oh, that is terrific.
So that's very eye-opening. You spend an entire day, once a week, focusing on your business and not being in the business working.
Oh, that must be nice to do. Get out of the business, but learn from other people.
Yeah, it's peer learning, and they bring in PhDs from all over the country to talk to us about negotiating and leadership. It's, things you think you know until you hear an expert, and then you realize, oh, I wasn't doing that quite right.
Well, good. Offline, you'll have to tell me what you've learned.
Yeah. How about you? What's new in your world?
I've been busy lately. A few months was slow, then all of a sudden, just like everything else, the law biz tends to be somewhat cyclical. I was slow for a period of time, and then all of a sudden, I got extremely busy. I have a number of litigation matters in bankruptcy court that I'm working on, a number of large transactions that I'm working on. So right now, I have plenty to keep me busy.
Are there any big bankruptcies in the public eye right now?
Not really, no, and certainly not here in the Philadelphia area. Philadelphia has not had large bankruptcies for a while. Delaware, Southern District of New York have them, but as I think about it, nothing really large lately. But that doesn't mean tomorrow we won't wake up and all of a sudden see that some new large store chain is filed. But that happens all of the time.
Yeah, and usually it's a maneuver. It's not true debt.
Well, it depends on what it is. It's sometimes it's just a downside. When you have something like Borders a number of years ago, where you had the change in the industry, where people were just not buying books, they were doing things with Kindles, doing things online. They didn't have a choice, so they had to go in to downsize, and eventually they liquidated. Oftentimes, it's to sell off a division, or sometimes sell the entire company. I mean, if you think of back in the day of GM, they had some unprofitable divisions, so they had to get rid of what was not profitable in that time, particularly Fiat, that they sold off, and they've been able to recover from that. So
are we allowed to talk about very highly political things for a quick second about bankruptcies?
Absolutely.
How many bankruptcies has Donald Trump really had? Do you pay
4.
attention to that?
4.
Only 4.
Well, and I think it was 4. Casino. I think they were all casino related, and I will tell you, I did not spend a lot of time looking into the underlying reasons for the bankruptcies, if it was a question of debt service or what it was. There are so many reasons why somebody files for bankruptcy, and it isn't always because you don't have money. I was involved in a case, probably the first bankruptcy case I was involved in when I was a lawyer in Florida. We represented a condominium association in Miami Beach, and the reason we filed for bankruptcy was to reject the lease for the swimming pool because all of the owners of the condo were senior citizens and not using the pool. But it was a huge drain on the association, so we filed the bankruptcy just so we could get rid of that lease. So bankruptcy is often used as a particular type of business strategy. And again, when it comes to Trump, without having looked into it, I don't know why the particular bankruptcy cases were filed. I think they were all reorganization Chapter 11s. I don't think any was a Chapter 7, though.
So you said condo associations. I am in a condo association with a giant loan. Can we file bankruptcy and restructure?
Absolutely.
Really?
Yeah, we can talk about that. But there are a lot of things. All right, so let me just give you the little bit of background on this. One of the things that happens when a company files for bankruptcy, it takes all of its contracts, and the contracts have the name company in there. Now, there's a legal fiction when a company files for bankruptcy. It becomes known as company debtor in possession. Same entity, but it is a different legal entity. One of the things that this new legal entity gets to do is it gets to look at all of the contracts and decides which it wants to keep, which it wants to get rid of, and which it's not sure about. Those that it wants to keep, they do what's called assumption. They assume the contracts, and then what happens, again, this is technically doesn't happen on the piece of paper, is the contract, rather than the name company, it's now the company debtor in possession. Those that it wants to get rid of, it does what's called rejecting, and it just gets rid of it. The other side to the contract has an unsecured claim for whatever the damage is under the contract. And then the other ones you have until the end of the case, so you just sort of put that aside and you say, we'll deal with that when we deal with that. So in your situation, it is very possible that you would be able to get rid of it, renegotiate it. There are a lot of options. And when we sit down and talk about Goldman Sachs, we can also talk about your condo association.
Always looking for an angle to save money. So when we talk about year-end and this election, does it impact how people are doing business in your industry?
It's a great question. The answer is yes, and I have a particular view. I think that the current administration hinders creation of business. Remember, I represent primarily small to mid-sized businesses, and in the last 7 years, there have been about 450,000 pages of regulations. Most of those regulations make it far more difficult for businesses to operate their business. A lot of them make it difficult for companies to get additional capital. So from my perspective, the current administration has made it more difficult for small businesses to grow, and I would like to see a lot of those regulations removed to unleash the small businesses to their full capacity.
I think that's really exciting. The class that I'm taking, we talk about capital and getting capital, and so much of what traditional banking is these days is secured loans, and they're looking for collateral at personal guarantee, which makes it really difficult for a small business to take a big leap.
That's absolutely right. Whenever I'm negotiating on behalf of a client, I try to avoid a personal guarantee at all costs. The other side of that coin is that the lender is going to say, well, do you believe in your business or not? And I understand that, but it's not always that easy, because again, if the likelihood is the business is going to fail, you don't want to put your house and your other assets at risk. So let's find out other collateral that will provide the level of comfort that the company needs. Receivables, hard assets, whatever the company may have, and let's just try to stay away from the personal guarantee.
What does it really mean, a personal guarantee? I'm sure there's a lot of small business owners like me, and the bank says you have to give a personal guarantee, and I sign it. I've given them one, and I'm never one to shirk my debt, as much as I joke about trying to get my condo association out of the loan that they're paying. How does it work with a personal guarantee?
If the business can't pay, then you've agreed that you'll pay out of your pocket. And one of the reasons why you formed a business in the first place, whether it be an LLC or a corporation, is to avoid the risk of having your personal assets being called upon to pay for these debts. A personal guarantee says, if you can't collect from the company, come after me. And then if you can't pay on the personal guarantee, you get sued on the personal guarantee. And then if the company gets a judgment, then they can go after your assets. If you own a house by yourself, for example, that could be at risk. So that's why you want to avoid signing personal guarantees if you can.
That's a nice to have, right?
Yes.
That's good. Well, I have a question from you from the audience.
Sure.
This is something that I think a lot of us are interested in. This is from Joan Miller in Philadelphia. She wants to know, what are some cell phone privacy issues today?
I have to tell you, Joan must be following the news carefully, because in the upcoming Supreme Court docket, there are 2 cases on cell phone privacy. One is called Graham, and one is called Carpenter. And both of those involve criminals and the ability of the police to get certain cell phone records from the cell phone companies without a warrant. And there are a number of issues there as to whether they're allowed to do that. There's a split in the circuits. The Fourth Circuit says, if I remember this correctly, the Fourth Circuit says, no, you can't, you need to get a warrant. The Sixth Circuit says, yes, you can. You can get the underlying information, but not the content. And that's a lot of times what they're looking for would be locations to help the police try to solve some type of a crime. And so when there's what's called a split in the circuits, the Supreme Court often will take these cases up. So these 2 cases will come up during the term. Now, interestingly, and I know we haven't introduced Bob other than just briefly at the beginning, he and I were talking about this off camera, and he was relaying another story that's somewhat similar. So this would be a good segue to let Bob chime in on the cell phone privacy, and if you want to tell the story that
Well,
you're
let
telling.
me
Sorry
let me
about
not
that.
miss this. So I know this is an interesting question. We're going to keep talking about it. But if you have questions you want to send in to Money Matters, here's how to do it.
You can have your questions answered on Money Matters. Please go to our website, money-matterstv.com. On our homepage, click on the banner on the right that says Send Us Your Questions. While you're on our website, you can find information about our host and guests, as well as show notes and links about this show and past shows. Money Matters is also available as a podcast on iTunes and Stitcher, so you can listen to Money Matters while you're on the go. That website address, again, is money, M-O-N-E-Y, -matters, M-A-T-T-E-R-S, TV.com.
So it's really great. Thank you for joining us today.
Thank you for having me.
So Bob, what is your specialty?
I do, my specialty is intellectual property law. That's patents, trademarks, copyrights, trade secrets, and litigation relating to those causes.
All right. So then tell us, you guys were talking earlier about cell phone privacy.
Yeah, and this is actually something that was referred to, that was mentioned to me by my wife, who was served on a jury here in Philadelphia, where there was an issue of taking a minor across state lines, and it was unfortunately it was a case of sexual abuse. A chauffeur was hired to take a divorced parents couple back and forth from their home in Philadelphia to I believe it was the Hamptons, and there were two children, the son and a daughter, and the part of the case that the prosecution laid out was that whenever it was only the son that was in the presence of the chauffeur, there were unexplained, inordinately long pauses at rest stops along the along the New Jersey Turnpike, and that testimony corroborated the son's testimony that he was in fact sexually abused during that time, and they were able to establish those inexplicable length of times in the rest stops by using GPS data that was on his phone. So it was more incriminating evidence that basically corroborated the prosecution's own case.
So if we take that same topic and just talk a little bit more about it, with cell phone privacy, we talk about the carriers, but what about what happened in California? They wanted to go back to Apple, and they wanted Apple to give up the data. They're not a carrier.
No, that was an interesting situation where I understood both sides of the equation, the need to protect the privacy of individuals. It went beyond just the bad people, but does that give the authorities the ability to go into our cell phones? And that's the concern that they have. So you really do have this balancing test of how do you allow the authorities to do their job, but at the same time we have an absolute right and a need to have our privacy protected. And so I think eventually they did give up the information. They came up with some way. I think one of the things they were talking about was they can come up with some new type of code that would be limited as to the information that they could get. And it was a challenging situation at the time, and I saw both sides of the equation, and depending on the day I would take one side or take the other, because I don't think there was any one right answer for that.
I do appreciate that Apple didn't just roll over and hand over everything, and I guess the government was looking for a backdoor into the software.
You have to remember, one of the things that was interesting about that was there was the argument that we're only after these bad people, and if it could be limited to that, that's one thing. But immediately after that, you saw other police forces, municipal police forces, I think in Baltimore and other places, saying, well, we want to do the same thing. So now all of a sudden you're going down with the proverbial slippery slope. Where does it end? And so you really, really need to be careful, because you do have that challenge between the need to protect the citizenry with the citizens' right to protect themselves.
Thank you. Thanks for that explanation. So we should probably talk about your expertise, right?
So, sure. What do you want to know?
Well, intellectual property, different than patents? I just learned that you can get a patent for the number of clicks in a website.
Well, you used to be able to. I'm not sure that's the case anymore. Patents are kind of a one class of intellectual property. It relates to. There are actually three types of patents. There are, and I think what you're really referring to, what are generally referred to as utility patents. But there are also design patents, and there are plant patents. But the vast majority of patents are what are called utility patents, and those protect various classes of subject matter, articles of manufacture, which generally are considered to be something that doesn't have any moving parts, compositions of matter, which are chemical formulations, pharmaceuticals, and things of that nature, machines, things that do have moving parts, and processes. And in 2014, there was a case that the Supreme Court got its hands on called Alice Corporation. And Alice Corporation really put a very big constriction on what is considered patentable processes. And the upshot of that case is that if it is a process that can be otherwise done manually or with human intervention, then it's not patentable. It's no longer statutory subject matter.
What's an example of that?
Probably clicks on a web page. Those types of things can be done manually. I can tell you that there have been a number of patents that have actually been invalidated by courts because they've been determined to be no longer statutorily eligible subject matter. There have been patents. In fact, I'm working on a patent that was allowed, and then we got a notice that the patent was no longer allowable in light of the Alice case. And unfortunately, I can't give you the details on that.
That's okay. That's more than I can handle.
But it's an odd situation. There are a lot of, particularly in medical telemetry and record keeping and things of that, and electronic records for sending medical alerts or the like. The patent office has taken the position that all of these things are just either abstract ideas or they're something that a human could otherwise do.
So you can't patent a process for a medical alert?
It depends, without sounding too lawyer-like.
Yeah.
It depends on how it's described. I mean, you might be able to patent the apparatus. You might be able to patent the computer doing that is considered sort of a special purpose machine, but the process itself might not be patentable.
That's really surprising.
Yeah. So I have a question. As an avid watcher of Shark Tank,
Yes.
all the time people talk about patents, and one of the phrases that come up with all the time is one of the sharks will say, "Do you have a patent?" And they will say, "It's pending." Can you explain what does that mean, a patent that is pending?
Well, it basically it's a patent pending is really of no legal significance to the public at large. It basically is a way of putting your competitors and perhaps the world on notice that you have at least applied for a patent. And you can apply for a patent in two ways. You can file what's called a provisional patent application, which is more or less a first draft. It's an application that stops certain time clocks from running and gives you a 1-year time period to go back and prepare what's called a formal or non-provisional application, and really put some meat on the skeleton, and sort of dress it up and make it pretty. And either one of those things, once you do that, you're entitled to put patent pending on your product. I mean, to this day, it sort of amazes me. I'll go to a hardware store and I'll pick up a pair of pliers and I'll say patent pending, and it's like I don't know how this could possibly be pending. Pliers have been around since before the colonial period. So
I have a flashlight manufacturer as a client, and we constantly are updating patents and putting patent pending on packages. So
right, and that could very well be for the circuitry. Could very well be for the design. of the flashlight. There's design patents are kind of an interesting subset of patents because it really has to do with the ornamental appearance of a product, provided that the ornamental appearance isn't dictated by its function. So you think of a flashlight, everybody sort of thinks of a cylindrical object with a head at the end and the switch somewhere along the body. But you can have flashlights that are square. You can have flashlights that are stretchy and twisty and have all sorts of other features to it. And those things would be protected by designs more so than by a utility patent.
So is it true that if you get a patent here in the U.S., someone can go to China or somewhere else and basically make the exact same thing?
Well, it depends. Again, patents are jurisdictional documents. So a patent that you get in the United States is not enforceable in Canada or Mexico unless you have a Canadian patent or a Mexican patent, in which case, that you can enforce it there, but you can't enforce your U.S. patent in Mexico. You're enforcing your Mexican patent in Mexico. So what a lot of people do, a lot of sophisticated clients, will file applications under what's called the Patent Cooperation Treaty, and it basically is a way of filing an application at a central repository or a central office, and then later on designating which countries you want to go into and get patents, and then electing those countries later on and actually prosecuting the patent in those countries.
How expensive is a patent to get? And I guess the lawyer's fees are different than the actual filing fees.
Yeah, and even a simple mechanical patent in the United States, and when I say simple, I mean relatively. I don't mean to denigrate the quality of the invention. I'm just something that's not an overly complex. I'm not talking about a transmission, something like a spinal cage or some type of medical device that's implantable. Might be considered simple mechanical type of inventions. You're probably looking at anywhere between $5,000 and $10,000 to put an application on file.
Is that with an attorney's help?
That is the attorney's help.
Oh.
Then there's the filing fees. The filing fees on top of that, depending on whether or not you're a micro entity, a small entity, or a large entity, are generally, I think the micro entity filing fees are $350. The small entity is $700, and the large entity is $1,400.
It's not as expensive as I remembered. I thought it was around $20,000 before. So.
Well, it might be by the time you finish prosecuting it. Prosecution is a term of art that basically means there's a back and forth that goes on between the patent office and the patentee or his or her representative. And the patent office, sort of our job as patent attorneys is to take an invention and try to get the patentee a patent that is as broad as possible and at the same time being commensurate in scope with the invention. But if you, so our job, and I used to say to people, our job is to claim the universe. And if we come away with a dozen galaxies, then we've done our job. But if all we've done is got Pluto for you, it's probably it's probably not worth the paper it's written on. That back and forth, the interplay between the patent attorney and the patent office is called prosecution. And very often it has to be done multiple times before the patent office, before you finally whittled down the invention or defined the invention to the satisfaction of the patent office. Because the patent office is looking at all the prior art, all of the technical literature and the patents that go before that. And then at the end of the day, if they can't hold it up to light and see the same thing, they go, okay, that's fine, this is probably patentable, but it might be obvious.
Shifting gears a little bit. So from the business owner's perspective, what types of intellectual property issues should the business owner be thinking about that they might not normally think about to help protect assets within their company?
Well, brand names, trademarks, logos, those types of things that they're sort of synonymous, are often overlooked by a lot of businesses. And going back to your point earlier about bankruptcy and personal guarantees, a lot of times when a lender or an investor wants to put money into a company, they want to take a look at not only the hard assets, but the intangible assets like trademarks, patents, copyrights, and the goodwill that's associated with the trademarks. And those are of value to the company, not just because they add to the bottom line, but because they have a potential of being collateral for debt.
Now, most of the time, when there's the trademark office, and most
Right.
people who are going to get a trademark go through that process. But you don't have to. There's something, I believe, called a common law trademark.
That's correct.
What is that, and how does that differ from a registered trademark?
Well, common law trademark arises, all trademark use arises out of, all trademark rights, I should say, rather, arise out of use. And and I would say that probably 60%, 65% of all trademarks that are out there are unregistered. So they're common law trademarks. I think Spider-Man, for example, is not a registered trademark. At least it wasn't at one point in time. No one's going to seriously contest, though, that Marvel doesn't own Spider-Man as the trademark. So one of the advantages of having a registration is that it creates certain statutory and evidentiary presumptions. It creates the presumption that you, in fact, are the owner of the mark, and that the mark is valid and that covers the goods that are recited in the registration.
How is a trademark different than copywriting?
Copyrights have to do with works of authorship, original works of authorship, fixed in a tangible medium, which it's a statutory definition that has some judicial gloss on it, but copyrights cover sculptures, writing, visual works of art, choreography, recorded works, to name a few. They even cover pantomime. Go figure. And the registration process for a copyright, at least in the United States, is required if you have to assert your copyright in a court of law. So you don't have a common law copyright, unlike a common law trademark. The only way you can protect your copyright, enforce your copyright, is to register it with the Copyright Office, and then upon receipt of your registration certificate, then you can.
Thank you.
That's your ticket to entry into a court.
Yeah, thanks for the clarification. I know for me it's a little confusing. So we're going to wrap up the show. Thank you for being here today.
Oh, my pleasure.
Yeah. So next week we hope you'll join us again. It's going to be Stephanie Lance from Star Get Business and Marketing Strategies. Thank you for being with us today.